Yes,
Mr. Lords. In this case, I appear on behalf of Neil Rollins, together with the learned Mr. Ozin. And Mr. Ozin did not appear on the court below, but I did. And the Financial Services Authority is represented as it was in the court below, or courts below, by my learned friend Mr. Perry, Queen's Counsel, and Mr. Sam Grodzinski. Now, Lords, although the point... Well, I'm going to start slightly different, if I may. What I'd like to do, if it's not inconvenient to your Lordships, although I'm prepared to take a different course if it is to make a few introductory remarks, then look at some materials shortly in relation to statutory interpretation, then look at the context of Section 402 itself, then consider the case of Uberoy in the Divisional Court, then the case of Rollins in the Court of Appeal Criminal Division, and then, to the extent that I haven't dealt with many of the points in the case, deal with the case itself. I don't know whether that commends to your Lordship a pattern at least. No doubt there'll be diversions and so forth. But we submit that although the point certified concerns the power of the Financial Services Authority to prosecute under Sections 327 and 328 of the Proceeds of Crimes Act, at the heart of our submissions is the proper construction and correct interpretation of the function of Section 402 of the Financial Services and Markets Act 2000 within the context of that wider Act. Now, if we fail in those submissions, then candidly there's not very much left. If we succeed, on the other hand, there may not be very much left on the other side. The main thrust of the submissions is that the scope, focus and responsibility of the Financial Services Authority is the supervision of the regulated industry. And the particular act, FSMA, if I may call it that, for the purposes of brevity to your Lordships, created a completely new look authority with powers to prosecute principally offences under the Act, all or nearly all of which, those statutory offences, concern the regulated industry, with the principal exception being acting in breach of what is called the general prohibition. It also empowered ministers, Treasury ministers, to transfer the functions of the various mutual societies under Part 21 of FSMA to the Financial Services Authority, and granted such power as was necessary for those ministers to amend earlier legislation so as to substitute the Financial Services Authority as the prosecutor of the offences which hitherto, or up until that point, had been the exclusive or virtually exclusive preserve of the societies themselves. It also permitted the Financial Services Authority, at the time of enactment, to prosecute two other offences, since added to by a third, which gave it a slightly wider mandate. And those offences were insider dealing, and secondly, breaches of the money laundering regulations, and now a failure to comply with an information direction under Schedule 7 of the Counter-Terrorism Act 2008. This, in our submission, is what we would call the parliamentary dispensation. It fixed the position of the Financial Services Authority in the constellation of public life, whether as a regulator on the one hand or as a prosecutor. And the offences chosen by Parliament, were carefully chosen and chosen deliberately so that the mandate was made clear to all. This is not, I know it's suggested in my learned friend's case that this would be anomalous, that there'd be a requirement for two prosecutors and so forth in certain circumstances, but it's not particularly anomalous. The criminal law in this country has had a number of different anomalies over the years. For example, the director of the Serious Fraud Office may only investigate cases where he's of the opinion that there is a serious and complex fraud. Moreover, under Section 145 of the Customs and Excise Management Act, as originally enacted, only the Customs and Excise could prosecute certain assigned or classes of offence, which used to necessitate the instruction of counsel by two prosecuting authorities, the Crown Prosecution Service and the Customs and Excise Commissioners, in, say, a false invoicing fraud where there was an element of VAT. At the time of enactment, at the time of the enactment of CEMA, the Customs Excise Management Act, only the commissioners could prosecute VAT offences. I, of course, however, recognise, and I submit really this, putting it like, perhaps I recognise this is entirely rhetorical, but if I can put it like this, if anyone asked in the year 2000, a Member of Parliament or a Treasury Minister, or an official at the Financial Services Authority on the 14th of June 2000, which is the date of enactment, or indeed for many years later, whether or not the FSA could prosecute other offences, and in particular the substantive offences of money laundering, they would have said no. Of course, I recognise that it's the words of the statute that count, and not the belief of the citizens, however well informed. The matter didn't arise for many, many years.
I'm sorry to interrupt, but I mean, if the questioner had then said, well, do you think I can? What do you think the answer would have been then?
If an ordinary citizen could.
Yeah, the questioner, the
Yes.
ordinary citizen, the man on the Clapham Arms, he'd ask this politician, do you think they can prosecute for money laundering? You say they'd have got the answer no. And if you then go on and say, oh, by the way, do you think I can? What do you think his answer
I think
would
the
have
answer
been?
to your Lordship's question would be yes.
Oh.
Well, that much must be plain from the way I've put the case, my Lord.
Yeah.
I face up to that difficulty, and I readily acknowledge that difficulty right from the outset. But the question is, what did Parliament actually intend the mandate of the FSA to be? Does Section 402, in fact, limit the scope of the FSA to prosecute?
Because if it doesn't, then it would have the power to prosecute.
If it doesn't, yes, my Lord, yes. Yes.
But the question is whether or not the power it would otherwise have to prosecute is excluded by
Yes.
the section.
Whether or not Section 402 prescribes a complete list of specified offences.
And has the effect of excluding
And
what would
has the
otherwise
effect-
be the private right to prosecute.
I agree with you, yes. And as I say, if I'm wrong on those submissions, there's very little left in the case for the...
But it depends on Section 402. It's got nothing to do with the Articles of Association or whatever they are of the prosecutor.
Well, I won't speak for the learned friends, but I would agree with you, Richard, yes. It's got to do with Section 4, because the Articles of Association and Memorandums can't expand the parliamentary powers.
Or narrow them.
Or narrow them.
But anyway, you're not suggesting it does narrow them.
No.
Sorry, so you say what? 402 prescribes an exclusive list, obviously in addition to 401.
Well, yes, but exclusive list of non-statutory offences, or offences that lie outside FSMA. FSMA creates a whole raft of offences which, by virtue of Section 401, the authority is given the power to prosecute.
So
Section
just-
402
Yes.
is a few additional offences, 3 of them now, insider dealing,
Yes, yes.
breaches of the regs,
Yes, yes.
and Schedule 7 of the Counter-Terrorism Act.
And you say that is a prescription of all the other offences which they are entitled to prosecute.
Yes.
All of them.
All of them, yes.
I'm sorry, I must be
with
aberrating because I thought we'd discovered a couple that were...
Well, I know I've already mentioned the power of ministers to transfer the functions of some of the pre-existing mutual societies to the Financial Services Authority, which powers necessarily included, and which pre-existing powers included a power by those pre-existing authorities to prosecute offences contained within the earlier statutes. Building societies, friendly societies, and so forth.
So when were they transferred?
They're transferred by virtue of Part 21 of the Act. which is, I think my learned friend has produced a bundle, a much wider bundle than is before your lordships, but they're transferred by virtue of Part 21. And the effect of Section 426 of the Act is to permit the Treasury Ministers to amend preceding legislation prior to the year 2000 so as to permit or authorise, so as to substitute in the earlier statutes where it says, for example, the building so-and-so may, no proceedings for this offence may be instituted save by the Building Societies Commission or the Director of Public Prosecutions. For Building Societies Commission is substituted the words Financial Services Authority.
Mr. Biscuit, are there copies of the legislation?
Yes, there are.
Do you think we could maybe see them?
Yes,
I think it might be easier to follow.
Yes, of course.
What
I'm
you're
so
saying.
sorry, yes.
What you're saying.
Thank you.
Thank you.
Thank you. Thanks.
Yes. Well, I don't know what your lordship wanted. I suspect probably both. Your lordship wanted a copy of the order
And the
original
what
legislation.
you're referring to, yeah.
So, well, very helpfully, the learned friends have produced a copy of the whole Act.
Thank you.
Thanks.
I'm going to come to this in sequence, my lord, if I get there.
Yeah.
But if your lordship would like to look at the preamble to the Act just by way of introduction on the very first page, it is an Act to make provision. I'm so sorry.
Yes.
An Act to make provision about the regulation of financial services and markets, to provide for the transfer of certain statutory functions relating to building societies, friendly societies, industrial and provident societies, and certain other mutual societies and for connected purposes. And Part 21 I'm not sure I can tell because there's no index to this bundle, I'm afraid. 422, thank you very much. Section 422. Oh, page 4. No, I don't have your bundles.
Page 323. We don't have page number.
Section 334, I'm afraid. Thank you.
Section what?
334.
323. Yeah. Sorry.
334.
334.
Yeah. Part
It's a large
21.
court and people need to speak up.
Yes, I do understand that.
Yeah.
Yeah.
And the other section that I was referring your lordship to was section 426, which is in part 30. Section 426. There's the section, my lord. Which enables Treasury Ministers to make orders which make such incidental, consequential, transitional, or supplemental provisions as he considers necessary or expedient for the general purposes or any particular purpose of this Act, or in consequence of any provision made by or under this Act, or for giving full effect to this Act or any such provision. Then if you'd be good enough to go to 4262B, for applying with or without modifications or amending, repealing or revoking any provision of or made under an Act passed before this Act or in the same session. So it's my submission, these are the enabling powers which allowed the subsequent amendment only to the earlier Acts, all the Mutual Societies Acts. And if your Lordship would like to look at the order as well at the same time, because that might be convenient to do it, but although this is, then I can take your Lordship to the order, which is a very lengthy document.
Be found where?
It's in the second bundle, just hand it to your Lordship. Not the pink one, the white one. There were two bundles handed up, a small one and a big one.
I see, the one
Open
I
on your
see,
Lordship's
yes,
left hand, yes. This order is made in exercise of the powers set out in the preamble, and I pointed to section 426 as the particular one. And it says in the commencement section, this order comes into the force for the purposes of Article 8 and the purposes of Article 4.3 and Schedule 2 on the 17th of August 2001, and for all other purposes on the day on which Section 19 of the 2000 Act, the general prohibition, comes into force. And if one goes over the page, you get the interpretation section, and then then you get to Article 4, the transfer of functions, and importantly, it says the functions of the Chief Registrar, Assistant Registrar, etc., of the Central Office listed in Part 1 of Schedule 1 of the Friendly Societies Commission, of the Building Societies Commission, are transferred to the Treasury, and those functions, my Lord, were largely legislative functions, as set out in Schedule 2. All other functions, which immediately before commencement were functions of those people, those bodies set out, are transferred to the authority, subject to any repeal or amendment made by or any provision of this order or by any other provision of or made under the 2000 Act.
So, I mean, was the position until that transfer that the exclusive power to prosecute under that legislation fell to those other bodies?
Yes, so I think there's a saving for the Director of Public Prosecutions. It's in... No, I think I'm wrong. I think in England and Wales it was the exclusive preserve of the commissions. And if your Lordship would then go, please, within Schedule 2...
When you say exclusive, do you mean that excluding also the ability of a private person, an individual, to prosecute?
I believe so, Lord, yes.
Well, we need to see that, don't we?
Yes. My Lord, I think I've got this right. It's tab 4 within the authorities bundle, isn't it? Yeah, it's the section. Yes.
I mean, the original authority, the pink one or the
Pink.
pink?
Pink. Authorities Volume 1, Statutory or Other Material. This, of course, is as it is printed today.
Yeah.
Yeah, but it substitutes the word authority for the commission. The effect is that it shows the substitutions.
In section,
Well, my Lord, for example, section 111, which sets out a time limit for commencing proceedings. And in Scotland, of course, under subsection 111.4, it's the ability of the Lord Advocate.
so where is the exclusion of private rights to prosecute?
Well, my Lord, I can't see one, to tell you the truth, but I would suspect, my Lord, that the answer is that the Building Society Commission, all of these commissions, had responsibility as a regulator for regard to the various offences contained within the statutes.
Well, I don't think we've got the relevant parts of this statute here. We've got one page which sets out Section 5, the establishment, constitution and powers.
Yes.
And then we've got a page which deals with time limit for commencing proceedings, and then liability of officers and defence of due diligence. But
Yes.
there must be other provisions which deal
Well, there's
with...
129 pages of them. We
Yes.
go from page 2 to page 131.
Well,
And indeed, the offences seem to go on after page 131. Or
yes. Yes, yes. Well, Your Lordship is entirely right. I suspect that, I just don't know the answer to Your Lordship's question. That's the answer, and I shall have to look that up, if I may. In relation to the Banking Act, which preceded this, there was a restriction on the powers to prosecute, and that is contained. If Your Lordship be good enough to turn to tab 5. These powers were transferred earlier. And if Your Lordship go to section 96, 5, that reads, no proceedings for an offence under this Act shall be instituted in England and Wales except by with the consent of the DPP or the bank. And in due course, the powers were transferred. Although there was no express disapplication of that statutory necessity in the transfer. But I was just going to come to, if I might, in the schedule to the 2000 order, the Mutual Societies order, paragraph 2 to schedule 2.
So we're back in this long order, are we?
Back in the long order, my Lord, yes.
Schedule 2, page what?
17. For the purposes of section 1.3 and schedule 1, which make general provision in relation to the authority and its functions, relevant functions are to be treated as functions conferred on the authority under a provision of the 2000 Act.
Paragraph 2 of Schedule 2.
Paragraph 2 of Schedule 2, my Lord, yes. And this schedule is headed Application of Financial Services and Markets Act 2000 to Transferred Functions. Yes. Yes.
Relevant functions are transferred functions. We
Yes.
get that in 1C.
1C, my Lord, yes.
So it's saying that these are to be treated as functions conferred under a provision of the 2000 Act.
Yes.
Is there a well-known statutory formula for excluding private rights to prosecute? I mean, Section 96(5) doesn't obviously exclude them; it simply provides for consent.
Yes. I think one of the typical formulas, and there may be more than one, my Lord, but there are examples in this case where it says proceedings for any offence under this Act may only be instituted by, and then sets out a limited cast of persons. Just like the one I've shown your Lordship in the Banking Act.
But that doesn't say that, does it?
It does, I think, Lord.
It says by or with the consent.
By or with the consent, yes, but it says no proceedings shall be instituted, save except by or with the consent of the director.
So a private person could prosecute
Theoretically,
if the DPP
consent.
gave consent. I agree,
Yes.
it's not perhaps likely, but,
Yes.
but that
that's
is
how
the
it
statutory
is.
position.
Yes, exactly.
And the other side of the coin is that the Director of Public Prosecutions can take over any prosecution.
Yes. That, of course, is the contained in the Prosecution Offences Act.
Including this one.
itself. Including this one. And indeed, in the parallel case of McInerney, the director is now prosecuting that case. And the
So
financial
your client's
services
simply
authority-
hoping that he won't do that.
I'm
And
sorry.
the purpose of all that is that your client's simply hoping he won't do that.
Well, I'm not sure about that, my Lord. It's obviously...
Otherwise, this is no doubt of great interest, but...
Well, it is of great interest. Of course, it may lose its interest in a few weeks' time or a few months' time with the creation of the Economic Crime Agency as well. So, and what's going to happen with the powers of the Financial Services Authority in relation to criminal enforcement, nobody yet knows. Anyway, I wonder whether I can leave that for a moment. I'm sure I'll come back to it in due course in relation to submissions about what are called the deeming provisions. Because one of the points we're going to make is that the only exception, the only cases which the learned friend has been able to point to in relation to powers outside, allegedly outside FISMA, are the powers contained in those earlier statutes, which, as we submit, looking at the transfer orders and so forth, it appears that the functions of the earlier authorities, which were then dissolved, were passed over to the Financial Services Authority. The earlier authorities dissolved, the functions transferred, and all that was done under the Principal Act. What my learned friend has not pointed to is to any statutes enacted after the year 2000, which have not been, so to speak, incorporated into the Financial Services Act itself. For example, 249 of the Banking Act, and so forth and so on. But can I come back to that in due course, or are there other instant issues that I can assist your lordships on? No. Well then, I reached the point where I was submitting that the point has not arisen for some years after the passage of the Principal Act, because the Financial Services Authority didn't prosecute people for serious indictment offences until a couple of years ago. And the second case it did prosecute is the case of Uberoy to which I'll have to turn shortly, and a father and son called Uberoy, when the Divisional Court had first to consider the role of Section 402. There are no other authorities that assist in our submission, although, of course, the only other places in which the section has been considered is in the court below, in the Court of Appeal Criminal Division. That's the only other court it's been considered in. There are no other authorities that assist, although, of course, the legislative history of the measure is admissible. And to use the words of Mr. Justice Blake in the Security Plan case, from the first intimation in a white paper through to the notes on the clauses in the bill, and even the headings in a statute, although I think Mr. Justice Blake was actually referring to the case of Montilla, which was in the House of Lords a few years before. Now, we
don't have notes on clauses any longer, do I? I thought they'd abandoned that years ago.
Well, I'm only quoting what we said. I'm making the point that the whole legislative history is admissible, my Lord, to consider the interpretation of the section.
Usually good to start with the section before one gets into the legislative history.
Well, I'm going to, my Lord, if I may, but I just want to make a few short points before I do. In Uberoy, the court was focused on the exclusive question of whether Parliament had either expressly or by implication disapplied the apparent necessity to obtain the consent of either the Director or the Secretary of State imposed by Section 61(2) of the Criminal Justice Act 1993. And it came under intensive scrutiny. Now, we're not saying necessarily that the overall conclusion of the Divisional Court was wrong. It may be. But we submit that a number of matters were not within the purview of the Court, and the overall purpose of the section as a whole was lost sight of. In the Court of Appeal, the decision of the Divisional Court was built upon, but we submit that the foundations upon which it built were insecure. And in particular, the place of these subsections, other than subsection 402(1)(a), was misidentified. Described by the Court of Appeal as untidy, the correct position of the section within the statute was lost sight, was lost. Now, can I say, so far as statutory interpretation, I recognise that there are many people here far advanced than me in terms of statutory interpretation. The fairly well-known authorities are in the authorities bundle, and those, of course, include the Black-Clawson case in Volume 2, Tab 1, and the famous dictum of Lord Reed in it. There is also the Spath Home case at Tab 12. And what I'd like to do, if your lordships will forgive me, is just because this is after all a public court, is to recite what I understand the principles of construction upon which at least I am operating, and so that those can be, so your lordships can at least understand where I'm coming from, where we're coming from. And it's in particular in Black-Clawson Tab 1, Lord Reed, at I'm going to use throughout, if I can, the pagination in the bundle rather than the internal pagination in the particular authority. If I can find my bundle.
Just dead within a month.
Yes, thanks.
So it's using the internal pagination of the overall bundle. It's 23.
73.
23, my lord.
23.
20, I'll keep my voice up. Sorry, when I look down, it rather disappears. In this case, he said, it appears to me to be unusually important to consider as aids to construction all other material which the law allows us to look at, and I shall first state my view on that matter. We often say that we're looking for the intention of Parliament. That's not quite accurate. we're seeking the meaning of the words which Parliament used. We're seeking not what Parliament meant, but the true meaning of what they said. In the comparatively few cases where the words of the statutory provision are only capable of having one meaning, that is the end of the matter, and no further inquiry is permissible. But that certainly doesn't apply to Section 8. One must first read the words in the context of the Act read as a whole, but one is entitled to go beyond that. The general rule in construing any document is that one should put oneself in the shoes of the maker or makers and take into account relevant facts known to them when the document was made. The same must apply to Acts of Parliament subject to one qualification. The Act is addressed to all the lieges, and it would seem wrong to take into account anything that was not public knowledge at the time. That may be common knowledge at the time, or it may be some published information which Parliament can be presumed to have had in mind.
And who's a liege?
A liege, well, we're all lieges, well, we live in a monarchy. We're subjects or lieges, aren't we? I think. We're not citizens. Although there are, I think, other authorities which suggest we might be. Anyway, that's, I think, the position about lieges.
I felt sure everybody except me.
I think it's a Scottish word, actually.
I'm so sorry.
I think it's predominantly a Scottish word. Certainly, it's common in Scots law. People talk about the lieges.
Is it?
So,
yes.
So I think that's why Lord Reid is reverting to that.
Then just a bit more. It's always been said to be important to consider the mischief which the Act was apparently intended to remedy. The word mischief is traditional. I would expand it in this way. In addition to reading the Act, you'll look at the facts presumed to be known to Parliament when the bill which became the Act in question was before it. And you consider whether it has disclosed some unsatisfactory state of affairs which Parliament can properly presumed to have intended to remedy by the Act. Unless my learned friend wishes me to read out anything further, particularly, or your lordships feel that there's some further emphasis to be added by other words, that's the particular passage that I draw to your lordship's attention. I take comfort from the fact that Lord Diplock, in the same case, where many other of the law lords found an ambiguity, thought that the words were absolutely crystal clear and there was no ambiguity at all. If I can just refer your lordships to one other passage, and that's the passage of Lord Simon at page 55, using the internal numbering. And it starts at letter C, 55C. Courts of construction interpret statutes with a view to ascertaining the intention of Parliament expressed therein, but as an interpretation of all written material, what is to be ascertained is the meaning of what Parliament has said and not what Parliament meant to say. This is not a self-evident juristic truth. It could be urged that in a parliamentary democracy where the purpose of the legislature is to permit its electorate to influence the decisions which affect themselves, what should be given effect to is what Parliament meant to say, since it is to be presumed that it is this that truly reflects the desired influence of the citizens on the decision-making which affects themselves. To this there are, however, three answers. First, an interpretation of all written material. In the interpretation of all written material, the law in this country has set great pragmatic store on limiting the material available for forensic scrutiny. Society generally thereby enjoys the advantage of economy and forensic manpower and time by concentrating on the meaning of what has been said to the exclusion of what was meant to be said. The material for scrutiny is greatly reduced. Specifically, experience in the United States has tended to show that scrutiny of the legislative proceedings is apt to be a disappointingly misleading and wasteful guide to the legislative intention. Secondly, interpretation cannot be concerned wholly with what the promulgator of a written instrument meant by it. Interpretation must also be frequently concerned with the reasonable expectation of those who may be affected thereby. This is most clearly to be seen in the interpretation of a contract. It's long been accepted that the concern of the court is not so much with the subject matter of consent between the parties, which may indeed exceptionally be entirely absent, as with the reasonable expectation of the promisee. So too, in statutory construction, the court is not solely concerned with what the citizens, in this case, through their parliamentary representatives, meant to say. It's also concerned with the reasonable expectation of those citizens who are affected by the statute and whose understanding of the meaning of what was said is therefore relevant. The sovereignty of Parliament runs in tandem with the rule of objective law. Thirdly, if the draftsman uses the tools of his trade correctly, the meaning of his words should actually represent what their promulgator meant to say. And the court of construction, retracing the same path in the opposite direction, should arrive via the meaning of what was said and what the promulgator meant to say. And he goes on, and I'm not going to recite it all, my lord, but he goes on to see over the page about the fallibility of draftsmen's offices, government departments, and so forth. At letter E on page 646, I can see no reason why a court of construction of a statute should limit itself in ascertaining the matrix of facts more than a court of construction of any other written material. That, of course, is Black Clawson. That is Black Clawson. That's before Papper and Hart. After Papper and Hart came the Spaffholm case. Lord Nichols, at tab 12, in particular, is cited frequently in relation to statutory construction here. At 331, using the internal pagination, 331F. Now, what I'd like to do is just, without reading it all out, for the sake of brevity, state what I believe Lord Nichols is saying in the passage from 331F down to the bottom of 333 at E. First, one should identify the meaning borne by the words in question in the particular context. Secondly, ascertain the intention of Parliament in the language under consideration, remembering that the concept is objective. Thirdly, per Lord Reid in the earlier case, seek the meaning of the words Parliament used. Fourthly, employ accepted principles of interpretation. Fifthly, as a starting point, language is taken to bear its ordinary meaning. Sixthly, read it as far as possible as consistent with human rights principles. Seventhly, use internal aids such as other provisions of the same statute. And eighthly, use external aids such as the background, setting, and legislative history. Ninthly, with regard to the latter, the courts are no longer restricted to look at the mischief that the legislation intended to cure, but adopting a purposive approach, identify and give effect to the purpose of legislation. Tenthly, the difference between the two is of constitutional significance, as citizens are intended to understand enactments and should be able to rely on what they read. This may give rise to a tension between a need for legal certainty and a need to give effect to parliamentary intention. The quote, at that point, he quotes Lord Diplock. It's at the bottom of 332H in the case of Fothergill and Monarch, where Lord Diplock says, the source to which Parliament must have intended the citizens to refer is the language of the Act itself. These are the words which Parliament has itself approved as accurately expressing its intentions. If the meaning of those words is clear and unambiguous and doesn't lead to a result that's manifestly absurd or unreasonable, it would be a confidence by Parliament and destructive of all legal certainty if the private citizens could not rely upon that meaning, but was required to search through all that had happened before and in the course of the legislative process to see whether there was anything to be found from which it could be inferred that Parliament's real intention had not been accurately expressed by the actual words that Parliament had adopted to communicate to those affected by the legislation. And then, 11thly, the courts are not confined to looking solely at the words of the statute and deciding whether or not the words are clear and unambiguous and do not lead to absurdity, as that would be too restrictive. No legislation is passed in a vacuum, and regard must be had to the setting in which the legislation was passed. But courts should be slow to allow external aids to displace clear language. And that is the context.
So we're looking for clear language, excluding the private right of prosecutor.
Well, one is looking at the interpretation of Section 402 and the clear words of Section 142, which are permissive. may. What does that mean, my Lord, is the point of contention here. But can I just finish this section, and I'll hurry on to the section.
Just before you do, can you confirm this is one of those increasingly rare cases where we actually aren't going to be concerned with the Human Rights Convention?
Yes, Lord.
Sadly. Or Hansard.
Or Hansard. Okay. There's no Hansard and no human rights. It's straightforward construction. In the context that the Act was passed. And the point I'm getting to, my Lord, is the explanatory notes.
Because you must be getting quite near to showing us the section, wasn't it?
Well,
I always hope. I live in hope.
Well, my Lords, I know it's full of suspense, but would your Lordships bear with me just a moment or two longer, and then we will get...
Lord Diplock would probably have started with the section.
We will get to that, but just setting the scene, my Lords, if I may, the backdrop to my submissions about the section. That's the point. I want to put up the scenery in which the principal actors play their parts.
We're approaching it as Mr. Justice Frankfurter said that counsel often proceed on the basis that one should only look at the section if the anterior history is not clear.
Explanatory notes, because they do play a part in my submissions here, and they play some role, play some important role. And of course, the status of explanatory notes has become increasingly important since they were first set out in, I think, 1998, when Parliamentary Council made a declaration to the effect that they were hereafter going to form a narrative to what were obviously increasingly complicated legislative provisions, so that people understood what was going through Parliament. And of course, they are cradle to grave. They're there from the original bill right through to the final act, and we have them in the bundles. But the
Have we the remotest notion who drafts them?
I'm saying something.
Do we have the remotest notion who drafts them?
Well, yes, they're drafted by the Treasury.
They're not drafted by Parliamentary Council.
No, they're drafted by the Treasury.
No, it's quite different, that.
I entirely accept that. They are drafted by the Treasury. This is the Treasury's own act.
Yes, but is it some misbehaving official who's given this as a punishment that he's got to write? How do we know what who drafts?
Of course, one has to place them in their proper context, and that's what I'm going to attempt to do as part of my scene painting operation. But so can I just start? The history in relation to this matter starts with the statement, the speech of Lord Stayne in the National Asylum Support Service case at tab 11, 272E. And indeed, Lord Stayne devoted his entire speech to the issue of explanatory notes, because he simply agreed with the opinion of Lord Hoffman on the principal issue in the case, but the rest of his speech was taken up with the approach to explanatory notes. And perhaps it's useful to start at paragraph 3 of the speech. The background is as follows. Brief explanatory memoranda used to be printed at the front of the bill. Such a document was a précis, didn't provide background. In addition, ministers were provided with notes on clauses which did, by and large, explain what a clause in a bill was meant to do. Later, in an era of greater transparency, notes on clauses were made available to backbenchers. In 1999, a new system was introduced. It involves publishing explanatory notes alongside the majority of public bills introduced to either House of Parliament by a government minister. See Christopher Jenkins, Queen's Counsel. First Parliamentary Council, helping the reader of bills of acts. The text of such notes are prepared by the government department responsible for the legislation. The explanatory notes do not form part of the bill, are not endorsed by Parliament, cannot be amended by Parliament. The notes are intended to be neutral in political tone. They aim to explain the effect of the text and not to justify it. The purpose is to help the reader to get his bearings, to ease the task of assimilating the law. The new procedure has the imprimatur of the House of Commons Select Committee on Modernisation and the House of Lords Procedure Committee. The explanatory notes accompany the bill on introduction and are updated in the light of changes to the bill made in the parliamentary process. Explanatory notes are usually published by the time the legislation comes into force. Unlike Hansard material, there are no cost to researchers involved. Explanatory notes of both bills and acts are published by HMSO. The notes are also available on the internet, etc. The question is whether, in aid of the interpretation of a statute, the court may take into account the explanatory notes, and if so, to what extent. The starting point is that language in all legal texts conveys meaning according to the circumstances in which it was used. It follows that the context must always be identified and considered before the process of the construction or during it. It's therefore wrong to say the court may only resort to evidence the contextual scene when an ambiguity has arisen. In regard to contractual interpretation, this was made by cleared by Lord Wilberforce in Penn and Simmons and in other cases set out there. Moreover, in his important judgment in the Investors' Compensation Scheme, Lord Hoffman made crystal clear that an ambiguity need not be established before the surrounding circumstances may be taken into account. The same applies to statutory construction. In Riverwear Commissioners and Adamson, Lord Blackburn in 1877 explained the position as follows: I shall state as precisely as I can what I understand from the decided cases to be the principles on which the courts of law act in construing instruments in writing, and a statute is an instrument in writing. In all cases, the object is to see what is the intention expressed by the words used, but from the imperfection of language it's impossible to know what that intention is without inquiring farther and seeing what the circumstances were with reference to which the words were used and what was the object appearing from those circumstances which the person using them had in view. For the purposes of the words varies according to the circumstances with respect to which they were used. Again, there is no need to establish an ambiguity before taking into account the objective circumstances to which the language relates. Applied to the subject under consideration, the result is as follows. Insofar as the explanatory notes cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed, such materials are therefore always admissible aids to construction. They may be admitted for what logical value they have. Used for this purpose, explanatory notes will sometimes be more informative and valuable than reports of the Law Commission or advisory committees, government green or white papers, and the like. After all, the connection of explanatory notes with the shape of the proposed legislation is closer than pre-parliamentary aids, which in principle are treated as admissible. And he refers to Cross on statutory interpretation. If used for this purpose, the recent reservations in dicta in the House of Lords about the use of Hansard materials in aid of construction are not engaged. And he refers to, of course, one case that I've already referred to. In particular, on this basis, the constitutional arguments which I put forward extrajudicially are also not engaged in a paper that he'd written. If exceptionally there's found in explanatory notes a clear assurance by the Executive to Parliament about the meaning of a clause or the circumstances in which the power will or will not be used, that assurance may in principle be admitted against the Executive in proceedings in which the Executive places a contrary intention before a court. This reflects the actual decision in Pepper and Hart. What is impermissible, this is the point, is to treat the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. The aims of the government in respect of the meaning of clauses as revealed in explanatory notes cannot be attributed to Parliament. The object is to see what is the intention expressed by the words enacted. And that is the first, and indeed I think the principal statement of the value of explanatory notes. It's referred to by Lord Stein again at tab 8 in the South Yorkshire police case, 225 C to E in the same bundle. And I would only add this.
What page?
I beg your lordship, pardon?
What page?
225.
Thank you.
225 C, there's the section on the explanatory notes. And I just draw your lordship's attention to 226A. The light cast on the interpretation of section 64(1)A by the notes is limited, but it does show exactly what problem Parliament was addressing. And then lastly, before I come to the section itself, is an example of its application at T16, page 398, in the case called Flora and Wacom, which was all about measure of damages. And to the judgment of Lord Justice Brooke, which starts at 398 in this regard. Paragraph 15 and 16 repeat really what has already been said. Paragraph 16 shows an example to which the courts put the explanatory notes as an aid to construction. The value, he says, of paragraph 354 of the explanatory notes as an aid to construction in the present appeal is that it identifies the contextual scene as containing a determination to ensure that the real value of periodical payments is preserved over the whole period for which they are payable. That is all. However, if it is impossible to treat the language as desires of the government about the scope of the language as reflecting the will of Parliament, it is my judgment equally impossible to treat the government's expectations as reflecting the will of Parliament. We're all too familiar with statutes having a contrary result to that which the government expected through no fault of the courts which interpreted them. Then, in paragraph 18, and lastly, the explanatory notes to the Courts Act 2003 is helpful. It's that it confirms the principal purpose of these provisions. It confirms that the principal purpose of these provisions is to achieve the aim identified by the Lord Chancellor when he gave his reasons for setting the discount rate mentioned in Section 1 of the 96 Act. There is a narrow line to tread, obviously, my lords, is there not, between treating the words of the explanatory notes as contextual and confirming the principal purpose of these provisions, on the one hand, and going beyond what is permissible and treating the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. It is a narrow line to tread, but I do submit that in this case it is possible to look at the explanatory notes in relation to Section 402 and other areas of the matter to see what is the contextual scene and to see also what purpose the provisions themselves actually were intended to, what the purpose of those principal provisions were. Now, Lord, the section itself and its immediate surroundings. This is now back in the large pink volume, the Authorities Volume 1, Statutory and Other Material, tab 10, page 88.
We're going to look at it there rather than in this natty little edition here.
Well, it's a matter for Lordship. I, of course, marked up the pink bundle.
You tend to have the small bundle.
And I don't have the small bundle. Your Lordship has both. Well, I do have a version of the whole Act, but it's not in the same format as the small bundle. But
Where do you want to take us in it?
well, my Lord, I was hoping to take you to page 88 of.
It is Section 401 in the same form in the two bundles.
I very much hope so. I haven't.
People tinker about endlessly with these sections.
I'm sure it is. I think it's important to see. This is part of. These form part of it starts at section. Can I start with section 401 and the heading above it, institution of proceedings? In this 401, proceedings for offences. In this section, offence means an offence under this Act or subordinate legislation made under this Act. Proceedings for an offence may be instituted in England and Wales only, A, by the authority of the Secretary of State, or B, by or with the consent of the Director. Proceedings in relation to Northern Ireland are then set out. Except in Scotland, under subsection 4, proceedings for an offence under section 203 may also be instituted by the Office of Fair Trading. That, of course, is instituted by the office as opposed to the Lord Advocate.
So who might bring these proceedings?
Only those people set out.
But
you could, with the consent of the Director.
Yeah. Oh, with the consent of the Director?
Exactly.
Yes. Yes.
So any private citizen with the consent of the Director.
Yes. Candidly, my Lord, in this day and age, I think it's very unlikely the Director would consent.
Well, that's just maybe.
But theoretically, my Lord, yes.
So it does contemplate proceedings, prosecutions,
Yes.
by somebody other than the authority, the Secretary of State, or the Director,
Correct.
It's
provided that that person has the consent of the
Yes.
Director.
This is section 401
Yep.
and deals with the statutory offences within the Act itself. In exercising its power to institute proceedings for an offence, the authority must comply with any conditions or restrictions imposed by the Treasury, and subsection 6, conditions or restrictions may be imposed under subsection 5 in relation to A, proceedings generally, or B, such proceedings or categories of proceedings as the Treasury may direct. So that's section 401, which deals allowing also always to your Lordship's point, but it deals with the powers of the Financial Services Authority. And in the words of the Court of Appeal, it confers a power on the Financial Services Authority to institute these proceedings, these statutory offences made by virtue of the Act. Then, section 402, the big one in issue, headed Power of the Authority to institute proceedings for certain other offences. 1. Except in Scotland, the authority may institute proceedings for an offence under A, Part 5 of the Criminal Justice Act 1993, insider dealing, the subject matter of the Uberoy case, B, prescribed regulations relating to money laundering, and 3, this was inserted later, added by the Counter-Terrorism Acts 2008, Chapter 28, Schedule 7, Para 33, Schedule 7 to the Counter-Terrorism Act 2008, terrorist financing or money laundering. They are, to say the least, an odd assortment of offences. And I'm not sure that anyone has put forward a reason why this selection is made. But that is the selection that was made by Parliament to permit, as I would say it, the Financial Services Authority to institute proceedings for certain other offences. And then, in exercising its power to institute proceedings for any such offence, the authority must comply with any conditions or restrictions imposed in writing by the Treasury, and conditions or restrictions may be imposed under subsection 2 in relation to proceedings generally, or such proceedings or categories of proceedings that the Treasury may direct. So the Treasury was to maintain control over its power to prosecute for these specified offences, as indeed it was to maintain its control over the offences, the specified offences in section 401. So, those are the words of the statute itself.
So little a and little b of subsection 1 were in the original statute?
Yes.
And the counter-terrorism point schedule
Was added later.
The only one added?
I'm sorry, Willie.
The only one added?
It's the only one added in 10 years. There it is. And I'll show it to your lordship in a moment, but it's contravention of an information requirement made under the schedule. So, my lord, it's useful at this stage to consider each of those subsections and see the context of each of those subsections. May I start with the insider dealing? That is 4021A, Part 5, Proceedings for Offence under Part 5 of the Criminal Justice Act 1993, insider dealing. And that is to be found in T7.
What was the word omitted? Was there a relevant bit omitted in the claim?
I suspect, my lord, it's probably
And. Okay, thank you. Thank you.
So is the, between 401 and 402, does 401 deal with generally who may bring proceedings in respect of offences under the Act?
Yes.
402 tells you what other offences the authority may prosecute for.
Yes.
That's
It doesn't confer upon the authority a power to consent to anyone else to prosecute those offences. It merely confers an authority on a power on the authority to institute proceedings for those offences. So,
I mean, just looking at them in the round, I mean, we're going to come to it in detail,
Yes.
but on the face of it, would otherwise have required the DPP's permission.
yes,
B,
all the Secretary of States.
all the Secretary of State. B and C, I mean, I know there are complications, but in broad terms, B and C were provided for limited classes of prosecutor.
Well, not at the time. At the time of enactment, there was no restriction on who might prosecute the money laundering regulations. And even when they were prescribed under the Act, there was no restriction on the power of anybody to prosecute money laundering regulations. That restriction comes as late as 2007 with new money laundering regulations.
Well, I mean, it contemplated it was going to be future, didn't it? Because it said prescribed. Or were they already prescribed?
No, they weren't already prescribed.
Well, then it was contemplating in the future.
It was contemplating the money laundering regulations 1993, which became prescribed. But even under the prescribed regulations, there was no inhibition on anybody prosecuting them.
So were there any regulations at the time of this Act?
There were, my lord, 1993. I'll show them.
I see.
And but can I come back to this?
Yes, no, please. I was just trying to get the shape of it. Yeah.
Thank you very much, Stu. Well, insider dealing, tab 7, my lord, same bundle. Page 30, using the internal numbering. The offence is set out on page 30. An individual has information as an insider is guilty of insider dealing. And can I just, whilst I'm here, because so I don't have to come back to it necessarily later, can I just point your lordships to subsection 2? An individual who has information as an insider is also guilty of insider dealing if he encourages another person to deal in securities that are, whether or not that other knows it, price-affected securities in relation to the information. Or B, he discloses the information to another person. But it's 2A that may have some significance. And I'll tell you, Lordship, what it goes to. It goes to the issue of conspiracy and so forth and so on, whether or not. Now, section 61(2) says, it's at the bottom, page 31, proceedings for offences under this part shall not be instituted in England and Wales except by or with the consent of A, the Secretary of State, B, the Director of Public Prosecutions. And then it deals with Northern Ireland in subsection 3. And that is printed as it is today. So, proceedings shall not be instituted in England and Wales except by or with the consent of the Secretary of State or the DPP. So that is the situation in relation to insider dealing. Now, as to 4021B and the prescribed money laundering regulations, at the time, the regulations were as set out behind tab 17.
So what's the purpose? I'm still troubled by what's meant by "or with the consent of." What's the purpose of that in this statute, for example, in the encyclopedia?
Sorry, what's the purpose?
What's the purpose of "with the consent of"?
It permits the relevant authorities to consent to others prosecuting it. But
Anyone they want, anybody they like.
But it restricts the class of persons who can prosecute to those people.
No, it doesn't. It was provided only by the consent.
Yes, but it restricts the class of people who may prosecute to those people who have the consent.
Yeah. But it could be anyone.
Theoretically.
Yeah.
Theoretically, it could be anybody, but you've got to obtain the consent of the Secretary of State or the Director of Public Prosecutions. So tab 17...
when it says except the authority may institute proceedings under Part 5, does that mean without the consent of the director?
Well, that's what Uberoy decided.
That's what Uberoy decided.
Yeah.
Yes.
Yeah. And your position on that is?
And our position is that it is possible that Uberoy is correct. They may be wrong, though. I mean, the question is a strict question of interpretation. Was Uberoy, was the divisional court correct in Uberoy? Does the Financial Services Act, does the Financial Services Authority in fact require the consent of the Secretary of State or not? And they held in what we submit was a fairly strained construction, and I'll come back to this, that the whole context of the Act overrode the express words in Part 5 of the Criminal Justice Act 1993.
But I'm sorry, so you say the better view would be that they still needed the consent of the DPP?
My Lord, not necessarily the DPP, but the Secretary of State.
Well, or the Secretary.
Or the Secretary of State. I'm not sure I need to go
Well, I'm not
down
sure how
one
far
way
you
or
need
the
to
other.
go, but I'm just wondering what your submission is. I mean, or don't you care whether they're right or wrong? Doesn't it make any odds?
It'd be more purist, your argument, if you said that Uberoy was wrong, wouldn't it?
It would be more curious.
No, purist.
It would be more purist. I mean, they accept, I mean, the court accepted that it's a strained construction that permits the conclusion in Uberoy. It's a strained construction of 402 that permits the conclusion that the consent requirement is disapplied. It is a very strained construction.
Surely section 402(1)(a) is vesting in the authority a particular power to institute proceedings which would otherwise not be there.
Yes. Yes. I mean, in one view, you can read the Act, as in the section 402(1)(a), as simply adding to the category of those people who may institute proceedings. But saying, so far as the authority is concerned, you're not one of those who consent to third parties prosecuting. Others, private prosecutors, rafts of people out there. It may read that. There is, but the question is why, in Uberoy, why didn't the draftsman specifically disapply the section in the Part 5 of the Act? Why didn't he?
Well, he didn't need to.
Well, my Lord, that may be the answer, but the way they looked at it in Uberoy was that they said, first of all, it was a very strained construction, and they may or may not be right about that, but they reached the conclusion on the basis that the whole overwhelming nature of the Financial Services Markets Act is so enormous that the plain intention of the Parliament was that it must have intended to disapply the consent.
Well, if you can compare 401, which does talk about the need for consent in certain circumstances, and
Yes.
with 402, which doesn't say anything about that at all, why should you import it?
Because, it is clear, is it not, that the draftsman had in mind consents, because he got 401 there, in which he precisely said only a limited class of people can prosecute without consent of others, of these people here. He doesn't do that in section 402. Why doesn't he say, and the requirement of the consent of either the director or the Secretary of State is disapplied. Because there is at least one other statute which does do that, as Uberoy refers to, not in this context, but in the context of the Criminal Justice Act, 1987. There is one might say, if you look at the Insider Dealing Act, there's an express prohibition on anybody prosecuting without the consent of the Director of the Secretary of State. That express prohibition, provided for by Parliament, required an express disapplication. That is one view.
But I suppose it would be subsection 1A, unless it modified, when read together with section 61, the provisions of 61, would be OTOs, wouldn't it?
It may fulfil a different function, section 4. What this section may fulfil...
Because the FSA would always have been able to prosecute with the consent of the Secretary of State or the DPP under section 61. And even on your analysis, it didn't need section 402(1)A to do that, did it? Or did it?
Well, what the tenor of the Act, what the Act does is, as follows, does it not? It transfers effectively many of the powers hitherto vested in the Secretary of State for all practical purposes for trade and industry to the Treasury as the overseer of the legislation. That's what the Act actually does. And it creates this company which is responsible to the Treasury in many ways, although it doesn't divest the Secretary of State of his powers, it allows the Financial Services Authority to carry out all the functions under the supervision of the Treasury. That's what the Act does, in my submission.
Can I be clear? I'm sorry if I interrupted.
Not at all.
I didn't mean... Can I be clear? I mean, before the 2000 Act, whilst the matter stood under the 1993 Act, I mean, is your position yes or no that the FSA could, with the consent of the Secretary of State or Director, prosecute for insider dealing?
Yes, it is.
They could?
Yes, of course.
But then your suggestion is that after the Act, 402(1)A does what? Simply perpetuates that self-same position.
Well, my Lord, this is the Uberoy dilemma.
I know, but what is your submission? That is what the Act does?
My submission is that if one looks at the provisions in section 402, it extends the power. It does a number of things, section 402, but one of the things it does is that it extends the power to institute proceedings to the Financial Services Authority for insider dealing. But that is only one of the functions.
You'll have to say that again, because I didn't quite follow it.
Without necessarily being briefed on the issue, if you know what, I can see legitimately that one of the functions of section 402 was to empower the FSA to institute proceedings as a non-statutory corporate body for the offence of insider dealing.
Without the consent of the Secretary of State.
Without the consent of the Secretary
or
of
the
State.
DPP, and indeed in the face of an objection by either of those.
Yes.
So it did change the position.
My Lord, section 402(1)A, without wishing to go nap on the thing completely, does, it would seem, extend the power to the FSA to institute that class of proceedings, yes. But that is not a complete answer to what the function of section 402 is. It's got more than one function. And what's happened in the case law, in Uberoy and in the Court of Appeal, is that because they've so narrowly focused on that function, they've lost sight of what the overall purpose of section 402 is. Can I turn to the money laundering regulations? As I said, I would, Lord. The regulations which were in force at the time are in tab 17.
I'm sorry, can I just, before you get there, I just want to follow through where we were.
Yes.
I mean, before this Act, with the DPP's consent, they could prosecute for insider trading.
Yes.
Assume that they had a prosecution on foot, having got the director's consent or the Secretary of State's consent. At the time the 2000 Act comes in, they can continue with that prosecution, can they?
Yes, of course, proceedings would have already been instituted by the Secretary of State in those circumstances.
Sorry, I thought they've instituted them with the consent of the Secretary of State.
Ah, yes. Then they could continue, certainly, yes.
Yeah. Very well, thank you. Yeah.
Thank you.
Sorry, tab 17?
Tab 17.
And they needed subsection 1A, because otherwise they'd be stuck with the consent.
Yes.
That was the purpose, the particular purpose of subsection 1A.
Well, that's the conclusion of Uberoy.
And it's the conclusion of the discussion we've just been having, too.
Yes, it is, yes. Yes. But so it is, yes, well, I'll say no more just a minute about that. The money laundering regulations at the time are tab 17, page 221. And these are the 1993 regulations, made in 1993, into force April 1994. They were made, as is set out at the top of page 223, the Treasury being a government department designated for the purpose of Section 2.2 of the European Communities Act 1972 in relation to measures relating to the preventing the use of the financial system for the purpose of money laundering in exercise of the powers conferred by that section, hereby make the following regulations. So, in pursuit of obligations, European obligations, these regulations were made, there are various offences, an example of which is Article 5.2. A person who contravenes this regulation should be guilty of an offence, an indictment or on summary conviction.
So what are you reading?
Article 5.2.
5.2, I'm sorry.
Yes, Article 5.2, my Lord, yes. Sure. Just an example of an offence under the regulations. And then we go ahead to a list of supervisory authorities at regulation, Article 15. But that's just a list of supervisory authorities. And I'm going to look at the explanatory note, I hope without objection. That's at page 245, just so that one gets the gist of what this is all about.
I mean, is there any regulation which tells us anything we can
No, there's no restriction on prosecution.
Anybody can prosecute.
Anybody can prosecute, without consent or anything. And it's the second paragraph of the explanatory note. Various words and expressions used in the regulations are defined. Where business relationships Regulation 3 are formed or one-off transactions are carried out in the course of relevant financial business, the persons carrying out that business are required to maintain certain procedures for the purposes of forestalling or preventing money laundering. These include the procedures set out in Regulations 7, 9, 12 and 14. They're also required to train their employees and more generally in the recognition of money laundering transactions and the law relating to money laundering. A person who fails to maintain the procedures is guilty of an offence. And where the offence is committed by a body corporate, etc., the directors and certain other specified persons are guilty of the offence. So those were the money laundering regulations in force at the time.
And is the FSA one of the supervising authorities?
Well, I don't think so, my lord, no.
It didn't exist.
Is it? I can't remember.
It didn't exist.
It is it?
The answer must be no.
I'm afraid I haven't spotted that point.
Who was it at the time? I mean, who was the FSA in those days?
In 1993, I can't remember if it was still the SIB or the FSA, but it was one of the, it only changed its name, so it was the Securities and Investment Board or the FSA, but it refers to it's Order 50 or Article 15.2c, a designated agency within the meaning of the Financial Services Act 1986. And I suspect that it's therefore it was one of the designated agencies. But if I'm wrong...
Or was it perhaps a recognised self-regulating organisation?
No, it wasn't an SRO, no. Yes. Yes, I was. Yes, thank you. I think what we're looking at.
So we're all agreed, are we, 15.2c?
I don't think we're necessarily all
okay.
agreed, my lord, but those are the supervisory authorities. Okay. I'm sure the Financial Services Authority was a supervisory authority.
I've written down includes predecessor of the FSA.
Yes,
is that right?
if I'm wrong, I'll be corrected by the FSA will know better than me about what its powers are at that stage. But our point is, Lord, nothing about consents. Then, what happened?
So hold it. I mean, so you're saying that with the regulations they then stood, there was absolutely no need for a 2.1b at all on the other side's case?
On the other side's case, that's correct, Lord. Yes. If this Section 402 fulfills the function of disapplying consents, then what is the role of Section 402(1)b? Obviously, it doesn't fulfil that function, or does not fulfil it wholly. Therefore, what does Section 402 do?
Does, if you go back to the money laundering regulations 1993, the supervisory authorities, as I understand it, include the predecessor of the FSA, is that right?
Well, I believe so.
Yes. And then these supervisory authorities under Clause 16 have to report things to constables, is that right?
Yes. 16.5, yes.
Yes. I just wondered whether possibly the object of Section 402(1)b was to, in effect, get round the need to report to a constable if you were going to prosecute.
Well, it's disclosable to a constable by virtue of the preceding provisions, and I suspect, my lord, that this is to do with disclosure requirements to the National Criminal Intelligence Service. In other words, if it comes to the notice of a supervising authority, that there are breaches of the regulations, then it provides a statutory gateway for the disclosure of the information to the police.
Sorry. Mr. Miskin, can we just look at the interpretation section and paragraph 3? There's a whole list of regulations to which money laundering applies.
Yes.
So far as England and Wales is concerned, are you submitting to us that none of those require any consents?
Well, I don't know is the answer.
I mean, it's something that may perhaps have to be checked at lunchtime.
But what it's saying is it's really defining what money laundering actually means, isn't it? I don't think it's concerned with powers of prosecution. It's merely saying this is the definition, or includes the definition of money laundering. So,
thank you.
I'm not sure, my Lord, whether you think it's therefore necessary to make the inquiries contemplated by your Lordship's question.
Well,
Yes, because it's an offence. If you go back to 402, proceedings for an offence under prescribed regulations.
Yes,
Which
but it's not going to make
wouldn't be under all these provisions set out in little 3 in the interpretation section of the money laundering regulations. Is that right?
Well,
In which case, which offence or offences is it limited to?
well, the offences under the regulations are basically offences of not keeping the books properly. That's it, not having systems of training in place. It's nothing to do with the substantive money laundering offences. It's simply to do with the regulations which all businesses, authorised businesses at that time, had to have in place within the regulated sector. They had to have them in place for the purposes of the attempted prevention of money laundering, which is defined, money laundering is therefore defined in the interpretation section. I don't think that's got anything to do with powers of prosecution. It's simply got to do with money laundering is this, and the purpose of these regulations is to set out various rules and regulations as to how we're trying to prevent that in accordance with European obligations. You've got to have a system in place.
So before, in the period 1993 to this Act, the predecessor of the FSA could have prosecuted under these regulations.
Yes. And so the point which we make, as I hope is fairly obvious.
And the FSA itself.
It could have, yes.
So it would have power to do that.
Well,
without section 4021B.
Yes.
So on your analysis, it had the power before section 4021B to prosecute under these regulations, did it? That would seem to follow from the way you treated subsection 1A.
I mean, you're saying, that's your case, that these provisions may have perpetuated a pre-existing state of affairs. But what you are asking us to do is to read into them the implication that therefore they can't do anything else. They can't prosecute in non-specified.
Well, my Lord,
though they could have before
No,
the Act. I mean, the logic of the concession in relation to little a and little b is that before the Act they had the power, but since the Act, the effects of section 402 is to exclude it.
I'm not sure I wish to be driven into a position which I didn't really intend to concede.
Well, I can see that.
You don't ever make concessions as one intends to make.
There were certainly powers in others to prosecute offences under the regulations, is where as far as I really intend to concede. Whether the FSA had power to prosecute under the regulations is a different matter.
What do you say is the purpose of section 402(1)(b)? What do you say it is?
It's the same answer. It's the same answer. It enables the Financial Services Authority as a body which is not a prerogative body, nor is it a statutory authority, like a local government organisation or other regulators. It enables them as a non-statutory corporation to commence proceedings in these specified extra FISMA offences.
But that means that they weren't allowed before. Because if they were allowed to do it before,
did they exist
they didn't
before?
need the power in section 402(1)(b).
Well, that's why I was at the point of, so to speak, not being willing to be driven into the position of consenting to the proposition that they could prosecute before.
But did it exist before the FSA?
Sorry, what?
Did the FSA exist before?
Oh, yes, my lord, yes.
So, the same body corporate?
The same body corporate, yes.
So where section 1.1 says the body corporate known as the FSA
Yes.
is to have the functions conferred on it by or under this
Yes.
Act, the same body, had pre-existing
Yes.
functions, did it?
But,
So if we wanted to know what their functions were before the 2000 Act, in the period we've been discussing,
Yes.
I'm going to have to look at some other statute.
yes, indeed, yes. But the position is this, what my submission is going to be, is that the FSA, prior to the passage of FISMA, was a very tightly controlled organisation with a very limited mandate to prosecute specified offences.
And which statute is that?
Well, can I come to that? Can I just finish? But I will come to it, Lord, I promise you. I won't forget. Anyway, so they were only prescribed. They became prescribed. These offences, tab 18. The Financial Services Markets Act 2000 regulations relating to money laundering regs 2001. The Treasury, in exercise of the powers conferred on them by sections, can I just draw your Lordship's attention to section 1684B, 4021B, which is where we are, and 417A, hereby make the following regulations. 2. The money laundering regulations 1993 are prescribed for the purposes of section 1684B and section 4021B of the Act. So at this point, they became prescribed regulations, and that statutory instrument, in my submission, thereby enabled them to prosecute the money laundering offences, which hitherto, must be the conclusion, they could not do. Otherwise, what is the point of this?
And where's the power to prescribe?
In the Act. Oh, but where's the power? Well, it says the Treasury, in exercise of its powers under 168...
That's why I'm asking where the power to prescribe.
Yes, I imagine it's 417A. I haven't...
It's the definition section, which refers to prescribed, means prescribed in regulations made by the Treasury.
Is that right? 417A?
Yeah.
Yes. 402 is the section which defines is the section we've been looking at. And 168 is an investigation section, empowering the FSA to appoint investigators to make inquiries about various things.
For instance, what is the sort of inwardness of this business about conditions or restrictions imposed in writing by the Treasury in 402, 2 and 3?
Well, I don't know, my Lord. All I know is that, for example, I believe that either the Treasury has imposed the condition or the FSA has voluntarily accepted the Code for Crown Prosecutors as being a condition for the purposes of the exercise of its powers under those sections.
And what's if? I mean, sorry, what I don't quite understand. In fact, I don't understand at all. Is what is the role of the Treasury and what is the role of the Secretary of State? They appear in different bits. What's the difference of the role?
Well, others in this room probably better than able to answer that question. But up until 2000, the reality was that the Secretary of State for the Department of Trade and Industry conducted these kind of prosecutions and still continued to do so after the passage of the Act. It's only very recently that the financial services authorities started to undertake these prosecutions, perhaps as a result of public pressure and criticism.
So when you say which prosecutions?
Insider dealing. It didn't prosecute anybody for insider dealing until 2008. The Secretary of State continued to do so, but the Financial Services Authority didn't. But then what happened is it widened its criminal remit. It took on a whole mass of lawyers and so forth and so on. But the effect of the Treasury is that this prosecutor is not superintended like the public prosecutors by the Attorney General, but is superintended by the Treasury.
Sorry, I'm being very slow and obtuse here, but the effect of the 2001 money laundering regulations is what, in terms of what was the pre-existing position?
Well, the pre-existing provision was that there is no one specified as being a prosecutor in the 1993 regulations.
Right.
Query whether the FSA could or could not. My submission is ultimately they could not. Under the Order 2001 number 1819, the Treasury prescribed the regulations so as to enable the FSA to institute proceedings under Section 402(1)(b). It was the order which the statute enables them to prosecute prescribed regulations. There were regulations, but they weren't prescribed. They are now prescribed by this order, and so the FSA may institute proceedings for them. I don't know whether that...
Well, so it's your submission that, I mean, until this 2001 order, the 2001 regulations, they were not able to institute proceedings under the 1993
I think that must be crystal clear, Lord, yes.
Because they weren't prescribed.
Because they weren't prescribed.
Well, that depends upon the true construction of whatever the statute was in force then, before 2000 was.
Yes. Yes.
So when did this part of the statute come into force?
Which part, Lord?
Part 27. What we're talking about, Section 402. When did it come into force?
Section
It's
402.
to be appointed. Here we are. We've got it. 19th.
Mr. Perry very helpfully says it's December 2000. I'm quite prepared.
2000.
2001.
What?
December 2001.
Oh.
So the section came into effect in 2001, December, by which time the regulations had already been
Had been prescribed, yes.
Are you going to develop your reasons for submitting that there was no power in the FSA to prosecute under the 1993 regulations before they became prescribed regulations?
Well, what I'm going to say, my lord, is that if one looks at the various delegation orders, and of which there are one or two in the bundle, the powers of the FSA in relation to prosecutions were limited to those to those delegated. That's my submission. So there was a provision. I'll turn to that now if your lordship wants me to.
Well, it seems to me that it is a rather important point on B.
Yes.
To understand B, we need to know what the power, if any, of the FSA was in relation to the 1993 regulations before they became prescribed regulations.
And to understand A.
And to understand A. Well, to the extent I can, I would submit the following. The history of the powers of the Financial Services Authority is set out in the Court of Appeal judgment, which is in tab 5 of the core volume. tab 5, paragraph 5. Various functions of the Secretary of State under the Financial Services Act 1986 were transferred to the SIB as it then was, pursuant to sections 114 and 201 of that Act, by the Financial Services Act 1986 Delegation Order 1987 and subsequent delegation orders. They included the functions of the Secretary of State in relation to the institution of proceedings in respect to certain offences under the Act. Similarly, various statutory functions of the Bank of England were transferred to the FSA as it by then become by Section 21 of the Bank of England Act 1998. Now, if your Lordship would go in the legislation bundle to tab 3, there are limited sections of the Financial Services Act 1986. Now, the Financial Services Act 1986 presumes the existence of an agency which was to become the Financial Services Authority, although it was originally called the SIB. Now, as I understand it, the only powers of prosecution that that authority had, and certainly this issue it's not been, so to speak, the subject of inquiry and debate between the FSA and ourselves hitherto. But as I understood it, the powers of prosecution in respect of an offence under this Act itself was set out at paragraph 201, and that is on page 16. Where it says, proceedings in respect of an offence under any provision of this Act other than section 133 or 185 shall not be instituted A, in England and Wales, except by or with the consent of the Secretary of State or the Director of Public Prosecutions, or in Northern Ireland. And then proceedings in respect of 133 above shall not be instituted in England and Wales, except by or with the consent of the Secretary of State, the Industrial Assurance Commissioner, or the Director of Public Prosecutions. And proceedings in respect to an offence under section 885 shall not be instituted in England and Wales except by with the consent of the Treasury or the Director of Public Prosecutions. And then, subsection 4, the functions to which section 114 above applies shall include the function of the Secretary of State under subsection 1 above to institute proceedings, but any transfer of that function shall be subject to a reservation that it is to be exercisable by him concurrently with the designated agency, which is the Financial Services Authority, and so as to be exercisable by the agency subject to conditions or restrictions as the Treasury may from time to time impose. If your Lordship would go back, please, to page 10, there was a power to transfer the functions to the designated agency set out in section 114. 1. If it appears to the Secretary of State that a body corporate has been established which is able and willing to discharge all or any of the functions to which this section applies, and B, that the requirements of Schedule 7 to this Act are satisfied in the case of that body, he may, subject to the provisions of this section and Chapter 14 of this part of this Act, make an order transferring all or any of these functions to that body. The body to which functions are transferred by the first order made under subsection 1 shall be to the body known as the Security Investments Board Limited, if it appears to the Secretary of State that it is able and willing to discharge them, that the requirements mentioned in paragraph B of that subsection are satisfied in the case of that body, and that he is not precluded from making the order by the subsequent provisions of this section or Chapter 14 of this part of the Act. An order under subsection 1 above is in this Act referred to as a delegation order, and a body to which functions are transferred by delegation order is in this Act referred to as a designated agency. And then it sets out which sections, the section applies to which functions, and it doesn't apply to certain functions. Over at paragraph subsection 9, the Secretary of State shall not make a delegation order transferring any legislative functions unless A, the agency has furnished him with a copy of the instruments it proposes to issue or make in the exercise of those functions, and he's satisfied that those instruments will afford investors an adequate level of protection, etc., etc. And there are various other provisions, including under 11, no delegation order should be made unless a draft has been laid before and approved by resolution of each House of Parliament. And 12, in this Act, references to guidance issued by a designated agency are references to guidance issued or any recommendations made by it, which is issued or made to persons generally or to any class of persons, being in either case persons who are or may be subject to statements or principal rules, regulations or codes of practice by it, or who are or may be recognised or authorised by it in the exercise of its functions under a delegation order, and so forth. Well then, what happened, my Lord, is this transfer the transfers were affected by what I believe to be a number of orders, but the first of them is to be found at tab 16. And this is the Financial Services Act Delegation Order 1987, whereas it appears to the Secretary of State that the Securities Investment Board Limited is able and willing to discharge the functions transferred by this order, and that the requirements of Schedule 7 to the FSA 86 are satisfied with respect to it. And then it sets out all those preconditions that are required, and I don't think unless it's necessary I'll read them all out, my Lord. And then if we go over the page, please, to Article 7, the function of the Secretary of State under Section 201(1) of the Act to institute proceedings with respect to any offence specified in Schedule 3 to this order is hereby transferred to the designated agency, subject to a reservation that it is to be exercisable by the Secretary of State concurrently with the designated agency, and so as to be exercisable by the designated agency subject to such conditions or restrictions that the Secretary of State may from time to time impose. So there was still a very tight rein held on the FSA at this stage. And the schedule, well, the function specified...
So this is about transferring the functions of the Secretary of State to the SIB/FSA.
Yes, but it's saying at this point that they're to be held concurrently, and it would appear that the Secretary of State was still rather the senior partner in the affair, if I can put it like that.
But the SIB could still prosecute, could it, with the consent of the DPP, for example?
I suppose, my Lord, I don't believe it could, because it's my submission that the FSA had very specific and designated powers. The whole nature and texture of these Acts of Parliament tends to presume that the FSA has very clearly defined functions and powers. That's my submission.
So if we go back to little a, our previous discussion,
yes,
we have to start from the beginning again. I mean, would on your analysis, the present analysis, would the FSA or the SIB/FSA have power to prosecute in respect of insider dealing?
No.
With the consent of the DPP?
No.
Well, that's a new answer.
Well, it is a
And
new
that's
answer.
the opposite of
yes,
the
yeah,
last answer.
Yes.
I think you probably have to. I think that has to be your answer, right or wrong.
Yes. But, my Lord, I think the position is this. Thinking about it, that my submissions, I think, have always been that the FSA is constrained by its powers to prosecute only a limited class of offences. So, in fact, if I made the concession, I did not intend to do so. Schedule 3...
So just before we, just so as I'm clear, if we look at, I think we were looking at paragraph 7, is that right? In the
Yes,
order. If one goes back to page 16, the version which we read earlier on, the paragraph 201 subsection 4, that second last line, at the time when that order was made, that would have read the Secretary of State, because I think that must be the case, because in subsection, in paragraph 7, it's subject to such restrictions as the Secretary of State may from time to time impose, whereas in the version we've got at 16, the Treasury has been put in, and of course the Treasury is what one finds in section 400 and whatever it is, 2.
Yes.
Is that right?
I think so, Lord.
Yes. and your point is, among other things, I understand that indicates that that the power of SIB or whoever they were, FSA, whoever they were, was restricted.
It's restricted, yes.
So
And always has been.
So they didn't have a freestanding power.
No.
That's your argument.
Yes, sir. And if I've gone beyond that, I didn't intend to do so. But that has always been our submission. Whether pre-act, pre-FSMA or post-FSMA, the FSA is restricted to the offences contained within the statutes.
So I'm sorry, so under the FSA 1986 legislation, section 201, until this delegation order,
Yes.
they didn't have the power of prosecution even with the consent of the Secretary of State or DPP.
Schedule 3.
Well, the answer is, I suppose that it's never been tested in practical terms. And if one looks at the category of offences in Schedule 3, this is the first delegation order. Offences under Section 4 carrying on or purporting to carry on an investment business without authorisation. Contradictions on restrictions on advertising, contravention of disqualification, direction, failure to comply with a requirement of investigation powers, false and misleading statements for the purpose or connection with applications in a question of application made to the designated agency, false and misleading statements, and so forth. Offences under Section 200. I would submit that this was an extremely closely regulated body, which is not to be presumed to have wide-ranging prosecution powers, and that it was never the intention of Parliament that it should.
But you don't get that out of Section 201, do you?
Not precisely,
Or Section 4.
Not precisely, my Lord.
On the contrary, Section 2101 suggests that any person would have the power to prosecute as long as that person had the consent of either the Secretary of State or the Director of Public Prosecutions.
Yes.
And subsection 4 is about something entirely different, which is the transfer of the Secretary of State's functions to this new body, and doesn't tell us anything about who the DPP could authorise to prosecute. I mean, subsection 4 is about something different, isn't it? It's about the transfer of the Secretary of State's functions, and we see in the regulations how that works, and as you say, there was some sort of joint prosecution.
Yes, but then one then comes back to the issue of what function does Section 402 of the Act fulfil? Why does Section 402, for the first time, mention insider dealing and money laundering regulations? This was something completely and utterly new. What's the purpose of Section 402?
Well, the purpose of subsection A is to remove the necessity of consent.
Well, one of the purposes. What's the purpose of section 402(1)(b)? Why is section 402(1)(c) inserted? And why is insider dealing mentioned in this Act for the first time when it's not mentioned in the Financial Services Act 1986? And the answer to these questions, in my respectful submission, if one looks at other aspects which we've yet to come to, is this was an expansion of the powers of the FSA, quite clearly, to take into account a permission to prosecute offences which were non-statutory and lay outside the Act with which it was principally concerned, whether that's the old Act or the new one.
In paragraph 114, the power to transfer functions means the power to transfer functions of the Secretary of State. Is that right?
Yeah.
Sorry, it's tab 3, isn't it?
Yes.
Yes.
Must.
Yes. Transferring all or any of those functions to that body.
So then if we look at, where do we find the powers of the body? The pre-2000 body, that is.
I'm not sure they're contained here in the sections that we have. And they varied over time because more and more powers were transferred to them, whether under that Act or under the Banking Act. I know the time is 1 o'clock.
I think we'll leave it now until 2 o'clock, Mr. Minister.
Thank you.